Hello, and welcome to the Montana Supreme Court Candidate Forum, sponsored by the Helena League of Women Voters. The candidates for the open seat are Kristen Juris and Dirk Sandiford. And we flipped a coin, and Dirk Sandiford is going to go first in answering our questions. So, my first question to you, Dirk, is why do you want to be on the Supreme Court?
Well, I'm running for the Supreme Court to try to help maintain the integrity of the court in what I believe is the increasing politicization of the court by special interests inside and outside the state. And we need to maintain the court as a fair and independent forum where cases are decided based on the rule of law under our state and federal constitution and on the facts of the case, and let the chips fall where they may.
And Kristen, why do you want to be on the Supreme Court?
I'm running for the Montana Supreme Court because the law is specialized. It's as specialized as medicine. And a diverse court is a better court. We need attorneys with experience from a broad variety of areas. Most of the members of the court come from a government background. There is nobody on the court who would bring 34 years experience representing farmers, ranchers, individuals, nonprofit organizations, small business owners in the daily legal issues that they face. 60% of the Montana Supreme Court's direct appeals consist of civil cases, so it would be good to have that experience on the court. A diverse court together is better than its single parts.
Thank you. And what in your background qualifies you to be on the Supreme Court?
Well, I'm uniquely qualified in this race. As you probably know, the cases, or the lion's share of the cases that go to the Montana Supreme Court, are litigated cases that come from our district courts. For the last 14 years, I've been an elected state district judge in one of Montana's busiest judicial districts, and all of the cases that go into the district courts and that go to the Supreme Court, all the types of cases, I've been deciding them in numbers over the years. Civil cases, criminal cases, and all of the subtypes of legal practice areas that come before the court. There's no substitute for relevant experience, and I have it.
Thank you. Kristen?
The Montana Supreme Court consists of 7 justices, and it is important to have somebody with a judicial background on the court. We currently have Justice McKinnon, who is a former judicial district court judge, and Judge Shea. But the experience that I would bring that is unique is the representation in the private sector. As I mentioned, farmers, ranchers, small business owners in the issues that they face, and actually being with them in the trenches, often against the government, is a different perspective than sitting on a case or hearing a case. In addition to my 34 years of practice, I have taught at the law school at the University of Montana for 16 years in the areas of property law, contracts, international law, agricultural law, business law, tax law, wills, and I've written several national textbooks and have learned how to research and write well. The Supreme Court is an appellate court. It's not a trial court, so it's different from the trial courts. We don't review evidence or allow witnesses. It's a review of the lower court's decision, and often looking at the legal issues that were raised in the lower case and deciding upon whether those legal issues were properly resolved.
Fine. And since the court deals with a wide variety of matters, how would you compensate for lack of experience in areas that you are unfamiliar with, or are there any?
Well, that's the beauty of this, is I don't have to compensate. Unlike my opponent, Professor Juris, I've been deciding these cases. And the legal issues from the cases that go from the district court to the Supreme Court are the same legal issues in the district court as they are in the Supreme Court. So it's a mischaracterization for her to suggest that somehow there's some area where that I'm lacking in experience because of my district court experience. The person in this race with the relevant experience is me. the areas that she suggests to you and to the public that she has this unique experience, those types of cases that get into the district court don't come from the practitioner's office, which is where she's been practicing prior to 2000. They come from the district court. So of the two of us sitting at this table, I'm the only one who has tried and true proven experience deciding all of that broad swath of cases over the last 14 years.
Kristen?
Would you repeat the question?
I asked, since the court deals with a wide variety of matters, how would you compensate for a lack of experience in areas with which you are unfamiliar?
Well, the 7 justices on the court, they deliberate after a case is heard. And so as long as there are some of the justices on the court who do have, for example, extensive criminal experience or extensive procedural experience, together as a whole, you're better than your individual parts. There is no attorney in the state of Montana who is a specialist in all areas of the law. The law is just too specialized. And it is important, district court experience is important, but as I said, 5 of our sitting justices who are very qualified, they have no prior judicial experience. That's not a prerequisite for serving, and in fact, the court is better served by having a broad variety. For example, none of the sitting justices, nor my opponent, has experience filing water rights claims, perfecting water rights claims, defending water rights claims, and water rights is going to become more and more important as we continue to adjudicate our 85 water basins throughout Montana. So not every justice is going to be an expert in all areas, but you're better together as a whole with a variety of experience.
Thank you. Dirk, do you think the legal environment in Montana has had a negative impact on business? And if so, do you have any statistics to back that up?
Well, I think that's an area where Professor Juris and I differ. She's been running around the states quoting statistics from the National Chamber of Commerce, which is a special interest group for businesses in this country. And from their perspective, they generally have a problem with judicial decisions. I'm not sure exactly why that is. All I can say is that in my years of experience in Montana's legal system, I have found our Supreme Court to be fair, impartial, and not biased against any type of litigant. They've made decisions as they saw that they were right on the facts and the law, and I think it's political rhetoric to suggest that our court is unfavorable to business. The facts are they just have not been unfavorable. We have winners and losers in individual cases. In my experiences, in 14 years of deciding business-related cases, sometimes businesses win, sometimes businesses lose. But when they lose or win, it's not because they're a business or not a business, it's because what the facts of the case were and what the applicable law was.
Kristen?
The U.S. Chamber of Commerce has issued reports over the last more than 12 years looking at the business legal climate of each of the states. And Montana is always ranked in the bottom tier of states for its business legal climate. There are several factors that attribute to that the report discusses. One of those factors is the lack of justices with experience in business law. When the court states in some of its opinions, for example, partnership law, it's very complicated, and quite frankly, we don't understand that. Or what is a capital account? It's helpful to have an attorney who understands the partnership laws, has drafted partnership agreements, has prepared capital accounts. Our court is also known as a court that you can either describe as activist or unpredictable, that it tends to legislate. In Jeff Renz, a professor at the School of Law, he issued a report saying that between 1990 and 2000, the court reversed itself 109 times. Rob Nadelson did a study between 2000 and 2010 and concluded that it had reversed itself 74 times. And that unpredictability makes it difficult not only for businesses, farmers and ranchers, but individuals to manage their affairs. No one wants a favor in court, an advantage in court. But what they do need to know is what the rules are and will they be consistently, fairly, predictably applied in my case.
Thank you. Please identify the greatest challenges to the Montana Supreme Court system and how can they be addressed?
Could you state that again? I'm sorry.
Please identify the greatest challenge to the Montana Supreme Court system and how can they be addressed?
Well, the system as a whole isn't just the Montana Supreme Court. The Supreme Court is at the head of Montana's judicial system and has supervisory control over all of Montana's lower courts. I think from a system standpoint, the Montana Supreme Court is in pretty good shape. It is handling its cases in a reasonably quick fashion, and the throughput there is good. The problem in Montana's judicial system is at the district court level, where the caseloads are disproportionate in the so-called urban districts in Montana and a few of the so-called rural districts, where the judges are overwhelmed by caseloads that they cannot handle in a timely fashion. And there's no indication, because of economic and social factors in this state, that that's going to change. The Supreme Court Administrator's Office and the Supreme Court, through the Chief Justice, is going to ask the Montana Legislature here in the next session to try to address that problem by approving 6 new judges in the districts most needy. But that's going to be a tall order for the legislature because it's very costly, and we don't have a lot of money laying around in the state of Montana to throw at these types of problems. So I suspect the legislature will do the best it can, provide some help, and the district court system will have to continue to do more with less.
Thank you. Kristen?
I agree with what Mr. Sandifer said, especially in urban counties. The increase in youth in need of care cases, and those are very time-consuming and demanding cases, place a burden on the district courts. One issue that I have observed as an attorney representing clients before the courts is it may be a year before you can have a trial scheduled, or months before you can have a hearing scheduled at district court, because in Cascade County, for example, because of these problems. Another significant problem with the system in whole is that lawyers are expensive. And it's a complicated system. If you are what we call a pro se litigant, a person who represents themselves in court, I believe that you're at a disadvantage because you don't understand these complicated rules. We need to figure out how to improve access for low-income people to the court. And there are areas where the court is trying to do that with improved forms, for example, that pro se litigants can use in divorce matters. There's other areas where those forms can be and should be expanded to. We should encourage attorneys to continue to provide pro bono services or free services. Currently, under our Judicial Code of Ethics, attorneys are expected but not required to provide 50 hours of pro bono services per year. And that's an area individually where I have strived to make a difference. In the past few years, I've spent over 300, 400 hours a year, almost a few months a year, providing pro bono legal services to those who otherwise wouldn't have an attorney, wouldn't have access to the system.
Thank you. Well, switching gears a little, what do you see as the major differences between the Montana Constitution and the federal Constitution?
Well, we don't really have enough time probably to get into a detailed discussion of that in this limited forum. It goes to the heart of the difference in the form of government that the national government at least is supposed to be. The national government under the federal Constitution is supposed to be and was intended to be a government of limited powers, with the states retaining and the people retaining the powers that were not otherwise specifically provided to the national government. And unfortunately, or fortunately, depending upon your point of view, I think it's unfortunate. The U.S. Supreme Court has expansively interpreted, for example, the Commerce Clause to give the federal government powers that I think were not intended. The state government here in Montana is a general government of general powers And the Constitution in Montana, particularly our 1972 Constitution, was revolutionary in this country, and is very forward-looking and protects our rights and our way of life here in Montana very well.
Kirsten?
I agree with that, and I'll just add a few other differences. Obviously, our 1972 Montana Constitution is much newer than the over 200-year-old U.S. Constitution. We also have the advantage of detailed minutes of the proceedings that were available that can be relied upon, to try to determine the intent behind different provisions. Whereas the Bill of Rights was an amendment, the first 10 amendments to the U.S. Constitution. Our Montana Constitution, Article 2, right up front, includes a Declaration of Rights, and it contains more rights than are articulated in the U.S. Constitution. So, for example, we were one of the first, if not the first, state to include a right to a clean and healthful environment, which is a constitutional provision that we'll see being interpreted more and more. We have a specific right of privacy, whereas the U.S. Constitution has been interpreted to include that, but doesn't expressly include it. We have the right to participate in government and the right to know. So it is a more detailed document than our U.S. Constitution.
Thank you. Would you prefer to have the Montana Supreme Court justices elected or appointed? Why or why not?
Well, that's a difficult question. There are pluses and minuses to both sides. Some states do it one way, some the other, and some have a hybrid system. My personal view is, frankly, is that Montanans have always held tight to the right to elect our judges. That was revisited in 1972 by our Constitutional Convention delegates. It was very hotly debated, and it was determined that we should continue to elect our judges. I think the thinking was then and continues to be by Montanans and certainly by our Constitutional Convention delegates that electing our judges makes our judges more accountable to the public that they serve. There are some problems with this that we are certainly experiencing in this election with the on all sides of it because of the political nature of it, unfortunately. But I think by and large it's a good system that has served Montana well, with the rare and narrow exception of the Copper King corruption era, which is now long gone.
Okay. Elizabeth?
I prefer the elected system, and it is part of our Constitution. The Constitution
Right.
specifically states that justices and all judges, apart from water court and some special administrative judges, shall be elected. And at the debate, the delegates to the convention kept returning to Section 1 of Article 2 that all political power is vested in and derived from the people, and that they are granted more power when they do have the right to elect not only the legislature, not only the governor, the executive branch, but also the judiciary. So they had concluded that this best fits our concept of popular sovereignty as expressed in the Montana Constitution. I support it, and it does have its problems, but so does the appointment process, as we have seen at the federal level. And it's an 8-year term versus a lifetime appointment at the federal level, which I believe may have its advantages as well. So I'm very happy with the system and the way it works.
Great. What do you see as the greatest obstacle to justice in Montana?
That's a broad question.
I know
There's a
it
number
is.
of answers to that. I think probably it's access to justice. It's so expensive for people, even of means, to afford lawyers and to prosecute or defend their cases in court. And the people who are the most burdened by that problem are the people often who need the most help. And those are the people that cannot afford to pay for representation in court. And they are underrepresented in our court system. As a result of that, they're severely disadvantaged through lack of technical knowledge. We do have some avenues of assistance, but not enough. We just don't have a system on the civil justice side where we have counsel available, competent counsel available to help people in the wide variety of legal matters that they need assistance with in times of need. And it's not because people in the legislature and in the government in general aren't aware of that, but it's very expensive from a public policy and tax dollar standpoint, but it's a very, very real problem, and particularly in our district courts is where we see it very directly when people come in and one side is represented by highly competent counsel, the other person is representing him or herself, and it's tantamount, and I often discuss this with people, to me walking into the hospital and saying I'm going to conduct an operation on myself. The results probably aren't going to be very good.
I echo that. I agree with that. 2/3 of the people, for example, in dissolution matters do not have an attorney. And another problem that we're experiencing is it's especially difficult not only for low-income people, but for people with either mental health problems, with serious drug or substance abuse problems, veterans, to obtain access, because they truly, when they come in pro se, face so many more obstacles than the low-income people face, that it's very hard for them, and many of them just drop out of the system and don't even try. So I'm very encouraged by the different types, the Veterans Court, the drug courts that different district courts have been pursuing, and we need to continue as a state to pursue those sorts of options. But as Mr. Sandifer said, it's expensive, and that's the legislature with many competing needs that they need to allocate relatively scarce resources. And how do you do that?
Thank you. And that brings me to another question, and that is, do you, what of the public defender office, which is mainly for criminal, is that right?
Not entirely. The public defender's office also helps indigent people in the child abuse neglect area of the law, and a couple of other narrow areas, but their primary function is to represent people charged with felony cases in state district court.
And how is that working?
Well, it's an underfunded system. It's not a system that is politically popular in the range of funding priorities that the legislature have, but it's a critical function that is constitutionally required in this country, that we people have the opportunity to have effective assistance of counsel when their liberty is at stake in our criminal justice system. And I know that the Office of State Public Defender, which is the agency who does that in Montana, is often criticized by people in the legislature on cost containment, often by people who really don't, frankly, understand the system. They do a very good job as a system. They're overworked, they're underpaid, they have inadequate resources, but watching them perform in district court over the years, they've done a good job, and they're very dedicated professionals. But that system is underfunded, and it's not as effective for our citizens as it should be.
And I'll just add, the legislature is aware of these problems, and they have authorized studies, both judicial redistricting to see if changes could be made. They have come out with their study on that, not recommending changes, as well as the public defender system. And judges will also appoint contract public defenders if necessary. And going back then, it's not frequent that a private attorney will undertake criminal representation on a pro se basis, but it does happen. The law school provides judicial assistance in criminal matters through one of its clinics, and getting the law school more involved in training students and having them do clinics and internships would be helpful.
Great. Would you like, our time has gone so fast, would you like to make a closing statement?
I would. Thank you very much for having this opportunity. We don't have a lot of time here. This race really boils down to two issues that make a huge difference between Professor Juris and I: experience and agenda. There's no substitute for relevant experience. I have it, Professor Juris does not. She will try to tell you that she has some niche or specialized expertise. She doesn't. The areas where she asserts that she has expertise in are areas where cases come into district court. I've been deciding those cases. She has no significant experience representing Montanans in court on these cases. She's been a transactional and office practice lawyer prior to 2000, and to her credit, a good one. She has very little experience in complex little civil litigation. She has no criminal experience handling felony cases in state district court. That's not youth court, that's state district court. She has no experience handling child abuse and neglect cases, constitutional law cases, a wide variety of other types of cases. There's no comparison between the two of us. The court is also no place for anybody with any type of philosophical bias or agenda. I have a 14-year record of deciding cases that come into our courts in a fair and impartial manner with no hint of bias or agenda. While I've been doing that, Professor Juris has been a religious zealot, an activist on divisive social issues. She's taken positions on such matters as anti-stream access, censorship positions versus newspapers on religious issues, and other matters as well. She's entitled to these views. This is the United States, but she cannot divorce herself from these views and put them aside. She's being supported in this race, among others, by out-of-state corporate money that is currently attacking me in television ads. Why are these people supporting her? They're not supporting her because of her vast experience. They're supporting her because they think that she will better do their bidding on our court. Montanans need to pay attention to what this race is about and get the facts. If you don't know, talk to lawyers in your community, talk to judges in your community. The best indication in support of what I'm trying to tell you is that every single one of Montana's retired Supreme Court justices publicly support me in this race. That represents a wide variety of people of disparate thinking. They haven't agreed on much over the years, but they agree that the court is at risk and that I'm the right person for the job. Thank you for the opportunity, and I would appreciate your vote in November.
Kristen?
Well, with all due experience, I do have relevant experience. Agriculture is the #1 industry in Montana. I have spent 34 years representing farmers, ranchers. I've been involved in representing natural resource, another important part of Montana's economy and the legal issues associated with that. I do have significant experience in courts, although I spend most of my time outside of the courtroom. I've certainly spent a lot of time in the courtroom, currently have 6 different cases pending, have dealt with constitutional issues, just got an order involving some constitutional issues issued a few weeks ago in a recent case that I've had. And although I'm not a criminal expert, I certainly am familiar with criminal law and have represented criminal defendants in court. As I do have the relevant experience, and in fact, I have experience that is currently missing from the court that would be an important and beneficial agenda. I bring absolutely no political agenda other than my desire to improve the court by bringing a missing piece of experience to the court. I am committed to the fair, impartial application of our laws, regardless of my personal beliefs, regardless of the status of the parties before me. I am a woman of faith, which is certainly different than being characterized as a religious zealot, which I am not. And to suggest that Christians are excluded from serving as a judge or serving in a political office is, quite frankly, discriminatory, and the voters must resist that sort of a notion. I fully support stream access in Montana. I have taught stream access in my property law class at the law school. The law is settled, and that is a distraction in this case. And I want to remind everybody that I won the primary 50 out of 56 counties by a 10-point margin without a penny of outside expenditures. It is not true that I can only win with corporate out-of-state money, and there will be money spent in the general election, not only on my behalf, but significant amounts of money on behalf of Mr. Sandifer as well, over which neither one of us has any control. I am the best choice at this time for the Montana Supreme Court.
Thank you. We wish to thank both candidates and HCTV for airing and recording this program, and to remind everyone to vote on November 8th. And we're hope that this provides some information that you needed. Thank you.
Thank you.